Are standing by to speak to legal analyst Mpumelelo Zikalala. We're going to be touching on Mpumelelo Zikalala with you on the defense essentially arguing about or presenting their case on the Section 205 witness and them not being furnished with the necessary documents. This is what we heard, because that witness was supposed to take to the stand today but is not available and will be coming on a different date. But this is what we heard from the defense in relation to how the state is treating this case. Let's hear from the advocate for accused number 3, Advocate Mnisi, putting it to the court.
It's almost 3 years now, but cell phone records are not yet ready, my lord. Now, the problem that we have with this kind of an approach is that each time we put a version to the witnesses that the states are calling, they come up with something new. Then come the next witness, we are also expected to put a different version from the first version that we would have put to the witness, on the basis of which we couched our defense based on the information that would have been available then, madam. This prejudices the accused person's defense in their case, madam, because at the end of it all, we are going to argue about the credibility and the honesty and the reliability of what these witnesses are saying, madam. It seems to me like the state was not ready from the beginning. And if that is the case, my lord, it is not an embarrassment for the state to stand up and say, my lord, we are still busy investigating this case. We're therefore requesting a very long postponement of this case. I don't think any colleague of us was going to object on that one, my lord, because then we would know that come that point, after that very long postponement, then we know that the state would have said, you know what, we've got all the information now. This is going to be a machine and a train that is going to run from Pretoria to Durban without any stops and goes, my lord.
Legal analyst Mpumelelo Zikalala, the stops and goes as suggested by Advocate Mnisi. Is it clear to you that the state maybe was not all that way prepared?
Good afternoon to you and also to your viewers. Yes, it does tell that, and what it does, it makes the job of the defense very difficult in terms of you can't really put version, as Advocate Mnisi stated, to the other side in terms of saying, yes, cell phone evidence that proved that my client was not there. Now, if you're going to provide this information in dribs and drabs, it makes the very process very difficult to try and defend your clients. And at the end of the day, they are going to be prejudiced in the manner in which this part of the operation has been going. All that is required from the state is to close all the information so that you're able to prepare accordingly, which is why, by the way, we hold things like the pre-trial conference to make sure that we're able to iron out all these particular issues, we're able to consult. Even if the piece of evidence is provided today, the defense is still going to need time to go and consult. And worst of all, they're not going to get an opportunity to recall all the other witnesses and say to them, if you're saying my client was there on the day, here's cell phone evidence that proves otherwise, what do you have to say about that? The manner in which the state is handling this particular case is not the one that should be followed by our. And the presiding officer should be coming in on this one to say, let me put a stop on these unreasonable delays. Make sure the state that you've all got your ducks in a row and you are ready to proceed at any time.
I beg your pardon, who's supposed to come in to make sure they stop the delays?
It's the presiding officer, the judge, because he's the one who controls the situation and controls the manner in which these particular proceedings are happening in. So if there are any of the parties which are misbehaving by not providing adequate information at the start, he's supposed to come in and say, it is my job to ensure that the unreasonable delays are eliminated. So I'm going to put a stop to this and say to you, make sure that when you bring evidence or witness to the stand, all the information has been passed over. We're not going to stand for these unreasonable delays and the extensions that you keep on giving, just so that you're able to go and prepare yourself and also to allow the defense to do the same.
I do beg your pardon, I do not know legal speak, but from what we have been witnessing, for instance, Constable Sizwe Zungu, who made his statement in 2023 already, I mean, things like that, are they unusual, where it would appear that the state is picking up so-called evidence as it goes along, with statements being made in 2023, to Advocate Mnisi's point that it has been so many years and to date there's still no cell phone records. And the presiding officer, it would appear as a layperson, from observation that is very quick to reprimand the defense, but on the state side, what has been your observation? Is there impartiality?
Well, it's very difficult to say or to come to a conclusion that there is none, but there have certainly been many instances in which instances of reprimanding legal reps has came from the side of the defense rather than the state, and which actually it should not go in that particular manner. You should treat these particular two parties in the same manner and say to them, I'm not going to stand for any unreasonable delays which are going to occur. So from the side of the state, if you request a postponement or an adjournment for whatever reason, make sure that you're able to provide plausible reasons of why you're requiring so. And to be able to come back and say, the only reason which is going to be understood and granted is going to be in instances where that unreasonable delay was due to instances which are beyond your control as a prosecutor. All other instances should be reprimanded. All other instances should be curtailed so that we don't find ourselves in these extended delays that we are facing now. Delays are bad for the family of Senzo Meyiwa because they want justice as soon as possible. And also for the defense or the people that are in the accused box. They pay this legal representation on a daily basis. And whenever there's a postponement or a day that collapses, it means that they are forfeiting the amounts of fees in which they have paid, and it's something in which cannot be repaid at the end of the day if they are found not guilty. So it's the presiding officer that should come in and make sure that the ship or the train is moving much quicker and much smoother by asking all these questions. Which witness are you going to bring tomorrow? Have you exchanged documents? Can you confirm that you've exchanged or received those particular documents? If that particular witness isn't ready, get another one person who can be able to come into the stand while you prepare all those things so that we do not adjourn this matter for the purposes of the other side to go and prepare.
In his defense, we did hear that from the presiding officer today, at least just before it got adjourned to resume at 2 p.m. But let's hear from the state. This is what the state had to say in their defense.
In any trial, there's massive information at the beginning of the trial. Some of it might appear not to be relevant at that stage, but later on during the trial, it becomes relevant and focus. The defense, we must keep in mind that we didn't even know what the defense is going to be of the accused, and when a version is put to the witnesses, then it becomes clear what the version of the accused is, and that massive information that was accumulated at the beginning of the trial would then be looked at, my lord, and the relevant portions as is indicative from the version that is being put to the witnesses will then be analyzed. And that is the situation in this matter. If the defense was to say, listen, we need more time to look at these issues, we don't have a problem with that, my lord.
Mpumelelo Zikalala, you speak of the family of Senzo Meyiwa and you speak of the men who are standing trial accused of this murder. What does this, though, tell ordinary South Africans who may not have a Meyiwa surname, who may not have a surname that would afford them the opportunity for the rest of the country to sit at full view and go through the proceedings? This has been a very high-profile case that ordinary people are following. What does it tell them about not just court processes, about justice in South Africa?
In fact, before I answer the question, it may not be a problem for the state that these delays are happening, but it is a problem for the Meyiwa family. It is a problem for the accused which are in the box because they incur expenses on a daily basis and they have to enjoy this process of sitting in court processes and having to listen and analyze certain things which are going to decide their lives at the end of the day. But what it does mean on a broader scale is the following. Maybe we need to relook the manner in which we handle our court cases. The very same notion of starting at 10 instead of starting at 9 or 8 is something that can be looked at. That's providing more hours in order for cross-examination to occur. Instead of finishing at 3, let's finish at 4, just like you and I when you are at work. Those 2 extra hours are going to come in and assist. But then from another perspective, those pre-trial conferences, they are supposed to be meaningful activities of the court or court proceedings, which are designed in a way of sourcing information as soon as possible, getting as many admissions as you may find, There's even a section in the Criminal Procedure Act that speaks on admissions alone to say, let's not bring witnesses which are not going to assist us in any manner. So if a witness is going to come in and admit to things that you've already known or to admit things which are not disputed, let's not call that particular witness because it's going to eliminate a whole lot of things which are taking place. So is this more innovative things that need to come in? The introduction of technology in certain instances where it would come in and a witness that don't even to come to court, you can read via your video link details. If you're able to do that, then we'll be able to curtail the time and get more cases done and get more justice covered in less time.
Thank you very much, sir, for your contribution this afternoon.